I don't know what they're doing. Yeah. Yeah, we saw that. I sent it to Sean.
He's going to be at that event.
What section does this go into in the stupid buyer disclosure? Yeah.
Good afternoon. I'm going to call this first meeting of the General Laws Housing Subcommittee post crossover to order. Members will answer the roll on the electronic voting device. The clerk will close the roll. A quorum is present. They all have bills to present, I guess. All right, Senator Reeves.
Good afternoon, Mr. Chairman.
Got Senate Bill 577.
Yes, sir. Mr. Chairman, members of the committee, this came at the request of the Virginia Military Advisory Council of Greater Northern Virginia and the leadership command and staff at Quantico. It has to do with some disclosures that in the realtor community, when you buy a house around the Marine Corps base, you're going to hear loud noises and your windows are going to rattle sometimes. And so working with the Realtors Association to come up with the language before the committee now, it's just going to say that they're going to put this little addendum in to the Virginia's Residential Property Disclosures Act buyer beware section to ensure proximity to military installations is included in that. So when you're looking for a home in Stafford or Prince William, you're going to know you could be potentially near the Quantico Marine Corps base.
Right.
It's a pretty simple bill.
Right. Actually, what it does is it says that we're not telling you whether you're near a military base or not, but you need to go check and for yourself, which is sort of the way we handle a lot of disclosures. We've looked at this form a lot, and we're probably going to mean no harm to your bill. I think adding this doesn't hurt anything, but we're going to be taking a look at this whole form over the interim because this is starting to get pretty lengthy, and there's a lot of stuff in here. Again, I don't think there's any harm to adding something at this point. This is sort of how we do disclosure in Virginia, or don't, right? Which is to say, here's something to be aware of that you probably would expect somebody to tell you, but they don't have to, so go ask for yourself. All right, any questions from members of the subcommittee? All right, is there anybody in the audience wishing to speak in favor of the bill? The realtors are giving me the thumbs up that they're okay with this approach, and this is y'all's preferred approach to disclosure, that's air quotes.
Mr. Chairman, I was just going to add on, the base commander is really, they have to field so many questions. So this really is a kind of an issue for them.
They'll understand. We had the same thing with the airport. So you see that one right above is 18. That was my bill from, I think, 2 years ago.
Yeah.
The same issues with the airports. Folks get sort of tired of answering, why didn't anybody tell me? And so we have something at least to point to. All right. Can we operate by motion?
Oh, they're not here. I'm sorry. Move to report.
All right, so moving to the second of the bill report. The clerk will open the roll. All right, the clerk. Oh, there you go. Clerk will close the roll. Bill report 6-0. Thank you,
Mr.
Senator
Chairman, members
Reeves.
of the committee, thank you.
All right, we're now waiting for patrons. All right. That's okay. All right, the committee will be at ease. The committee will come to order. There we go. We're back. All right. We have one Senate bill that we can, I think, handle without the patron presence. He's actually not a senator anymore. So, but we've talked this out. So Senate Bill 313 is very, very similar to a bill that House Bill 505. Do I have that number right? House Bill 1000.
So close.
House Bill 1055. I knew it had fives and zeros in it. All right. House Bill 1055 from Delegate Tran. Can I get a motion to conform Senate Bill 313 to Delegate Tran's bill? So moved and seconded that we adopt a substitute to conform this. As many as favor that motion will say aye. Aye. Those opposed? All right. You guys don't. All right. We like Delegate Tran's bill better. You guys like Senator Evans' bill better. They can't. I know. I've looked at. I know they can. Okay. Is there anybody in the audience wishing to speak in favor of the bill? Please come forward. Anybody wishing to speak in opposition to what we just did? Please come forward. Come on.
Thanks for the formality. Mr. Chair, members of the committee, I understand that Mr. Chair specifically believes that these bills cannot coexist, but in reading the language specifically in subsection J of the statute, if you read them together, while they accomplish two different things. The only thing that's not the same in the bill isn't substantive, it's just a mere language in subsection C, where it's both of them address maintenance fees. It's just that the way that it was worded by the drafter is different. So if you read it together, they accomplish two different things. And I can...
No, I understand. I understand that Delegate Eben was trying to get at something slightly different. We did look at these two subsections, though, earlier in the session with Delegate Tran's bill. And, we did come up with this idea just last year that you could pay, the formula wasn't that you have to have one free form.
That's correct,
And then you
yes.
could charge credit card fees. He says you can't charge the fees beyond what's charged ever, regardless of whether you offer a free form or not. So it's a slightly different approach to the same problem. And I get that there's some value in both approaches. I think what we'd like to do for now, and of course, Senator Bennett Parker, somebody can reject these changes, we can send these bills to conference, and maybe we can get the best of both out of them.
Yes, sir.
Does that sound okay?
I accept the committee's recommendations.
Okay, all right. So it's been moved and seconded that so we have the substitute now. So now we got the bill.
And the bill, I believe, is HB 1005.
HB 1005. All right, so there's been a motion to conform it to 1005. It's seconded, that's passed. We now have the bill before us. Is there a motion on the bill? It's been moved and seconded that we report with substitute. The clerk will open the roll. The clerk will close the roll. Bill report 6-0. Thank you. Delegate Williams-Graves. Senator. I was so good about that yesterday. I didn't mess it up once.
I had so much fun in the house. It's okay. I don't care what you call me as long as you call me.
All right, Senator Williams-Graves, you've got a good bill. Tell us about it.
Thank you, Mr. Chair and members of the committee. SB 184 is a consumer transparency bill for shipped goods. The bill before you ensures reasonable, practical consumer disclosures when goods are shipped pursuant to an automatic renewal or continuous service offer, while recognizing modern e-commerce practices and avoiding unnecessary burdens on businesses. As online shipped purchases continue to grow, many consumers receive goods with little or no documentation. I have quite a few at my house that my husband has ordered. Without clear invoices or instructions, consumers are left confused about shipping charges, unable to easily return products, or unknowingly have enrolled in an automatic renewal or continuous service agreement, which is something that happened to me personally. This lack of clarity creates unnecessary disputes and undermines consumer trust. SB 184 updates the Virginia Consumer Protection Act to require basic transparency when goods are shipped to consumers as part of a recurring transaction. Specifically, the bill requires that all shipped goods have the amount charged for shipping, if any, information on how to return the good if returns are accepted, and clear information on how to cancel the automatic renewal or consumer or continuous service offer. The bill focuses only on recurring purchases where consumers are most likely to experience confusion, unexpected charges, or difficulty stopping future shipments. I can keep talking or I can stop. Quit while I'm ahead.
So this is, I ordered the umbrella of the month club, and it keeps coming. All of a sudden I realize I got 35 umbrellas. I don't need them anymore.
I literally ordered a cutting board and was automatically enrolled into a membership that was in the very, 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 very fine print. And I kept getting these $39 charges. My husband has ordered things offline, and they come every month, and there's nothing in the package that tells you how you can cancel. Yeah.
Okay. Yeah, we've done this, I think, already for subscription, like electronic things, but this is actually for goods that keep showing
Yes.
up at your house.
Yes.
All right. Any questions from members of the subcommittee? We understand what we're trying to do here? Anybody in the audience wishing to speak in favor of the bill? Anyone here in opposition?
Move report.
It's been moved and seconded the bill report. Clerk will open the roll. The clerk will close the roll. Bill reports 6-0.
Thank you.
Thank you,
You have a good day.
Senator, thank you, Senator. Senator Favola.
Thank you, Mr. Chairman and members of the committee.
It's a bill I'm familiar with.
Senate Bill 177.
Yes, go ahead.
Well, this is very familiar to you, as you know, and it did become law. It's a bill that protects sexual and reproductive health data in many venues, especially when you're purchasing products in that space. So I have one amendment. That's what my bill says, that the law, as we currently have it, will not apply to non-public personal information that would be covered under the federal Graham-Biley Act. That's just a federal act that governs banking. So there would be very few instances where, a consumer purchase would end up, in the banking space. And they have to follow the federal law anyways, and they just wanted to make sure there was no conflict between state and federal. And there's no opposition to this. My stakeholder group had all the usual usual participants, Repro Rising and Planned Parenthood, as well as the banking folks and others. So,
Gotcha. Anybody here to speak in favor of the bill? No, it's not an amendment. I think the bill is the bill amends one provision of the law that we adopted last year.
yeah, right.
Good afternoon, Mr. Chairman, members of the committee, Trustee McDonald, the Virginia Bankers Association. Again, we'd like to thank the patron for bringing this forward, as well as working with the SLIQ work group. Certainly, appreciate working on this piece of the Valley bill. But glad to answer any questions, but appreciate your support.
Thank you. And Senator, just to be clear, I think this was made clear on the Senate side too, but there are a number of people that came to you asking, I think, to be exempted from the bill. This is the only one that we said yes
It's the
to.
only one I agreed to.
And this is the only one we will agree to, you think?
I hope that's your wish.
All right, good. So we don't keep having people come back. All right. Committee operates by motion.
Second.
It's been moved and seconded that the bill report. Clerk will open the roll. The clerk will close the roll. Bill report 6-0.
Thank you.
Thank you. All right. We've still got
Two more.
Senator.
Srinivasan or Beats? Somebody.
Senator Srinivasan. Take your time.
Thank you. Good to see you all.
All right, so you got Senate Bill, oh, wow, Senate Bill 666.
666. Good afternoon, Mr. Chairman, members of the subcommittee. Senate Bill 666 directs the Department of Housing and Community Development thank you so much, to create a centralized, publicly accessible housing development database that compiles key information from every locality in a consistent, readable format to track housing data. The database will track both existing and new housing developments. For new developments, it will record how many plans are submitted and approved, the number of units produced, affordability levels tied to area, median income, approval timelines, and basic unit characteristics. For existing development, it will capture the availability and duration of affordability restrictions and approval timelines, importantly. Importantly, this provides radical transparency for our most vulnerable residents, Mr. Chairman. The database tracks units with long-term income restrictions at 80, 50, and 30% of AMI, as well as when those protections expire, giving policymakers the key information they need to proactively preserve affordable housing before it's lost. SB 666 also shines a light on structural delays driving up construction costs by reporting average approval timelines for single-family and multifamily developments broken down by each phase. This allows us to identify bottlenecks, highlight successes, and target solutions to get more homes built faster and more affordably. This bill is about transparency, Mr. Chairman, and making data more accessible to lawmakers as we work towards addressing Virginia's housing crisis. I respectfully ask for your support for Senate Bill 666.
Thank you. Any questions from members of the subcommittee for the senator? All right. Anybody in the audience wishing to speak in favor of the bill? Anyone in opposition? No opposition. So moved and seconded the bill report. Clerk will open the roll. All right. The clerk will close the roll. Bill report 6-0.
Thank you, Mr. Chairman and committee members.
All right. Senator Deeds.
Yeah, I've got Senate Bill 803, and I think there's a substitute for it. Do you have the substitute? Okay, let me explain the bill first and adopt the substitute if you like it.
Okay.
I introduced this Bill 803 at the request of a constituent who was concerned that the law was not sufficient to meet some of her housing concerns with a homeowners association discrimination. So it was a quid pro quo bill. You had to prove, if you proved discrimination was occurring because of your race, because of your religion, because of anything about you, if you could prove discrimination, you'd have a cause of action under the Fair Housing Act. The Attorney General was concerned that the language itself might limit the applicability of some federal statutes, so that the statute base or I guess the substitute comes from the Attorney General's office to include all of the HUD regulatory language so that all forms and features of harassment are covered comprehensively, to ensure the approach of the state law remains as strong as the Federal Fair Housing Act. They said that failing to do so could weaken fair housing rights for Virginians and would also risk federal HUD dollars by putting the state law out of substantial equivalency status with the federal law. So that's what the substitute does. It still incorporates the quid pro quo harassment my constituent was concerned about, but it includes other aspects of the federal law.
So I'm looking at what's online, and this doesn't seem to. Let's move the substitute first.
Move the substitute.
It's been moved in second. We adopt the subcommittee substitute. As many as favor that motion will say aye.
Aye.
Those opposed? All right. So now we're looking at the substitute, which is before us. The one that I see online seems a lot shorter than the email that I got from the Office of the Attorney General.
Well, the substitute that I got from the Office of the Attorney General has 121 lines, and the substantial difference between this substitute and the bill that I had introduced is on lines 51 through 57. They describe hostile environment harassment, and they include that in lines 113 through 119. And this code section is just broader than the bill I introduced. And as I read to you the note from the Attorney General's office, they were just concerned that my bill would take us out of compliance with federal fair housing law. Even though we met my constituents' desire. I mean, and the bill I introduced was based on a law that had taken effect in Colorado.
Right. I don't see the totality of the circumstances. Oh, there it is. It's at the very end. All right. I see. All right. The one I have in my, the paper copy that I have, I think maybe I was having problems scrolling. Okay. So you took the approach of taking everything and trying to duplicate as much of the federal law in here as the OAG had suggested.
I think that's what and the substitute came directly from the Attorney General's office. I mean, I think they drafted the bill to become more comprehensive than the approach of the bill that I had drafted.
Right. Okay. Any questions from members of the subcommittee about this for now? Is there somebody online? I think you have somebody who's online. Is there anybody here in the audience wishing to speak in favor of the bill here in the room? Anybody in the audience wishing to speak in opposition to the bill? Okay, I do see that you have somebody online. So let's go ahead and hear from Ms. Hudson.
Tanisha Hudson.
Tanisha Hudson.
Hello, everyone. My name is Tanisha Hudson. I am the individual who worked with my amazing Senator Deeds to push this legislation because of a personal experience that I experienced living in a homeowners association here in Charlottesville, Virginia. My homeowners association is responsible for the exterior maintenance of my home. And in the process of doing a re-siding project, they caused damages to the exterior of the home, and it led to some construction defects, which led to a rat infestation and some additional, wasps and bees coming in through the construction gaps. Also water intrusion and some other issues. In the process of me pointing out these damages to my HOA, they initially refused to fix the damages, which my windows was the first thing that they damaged. They took all the head flashing from around my windows. Instead of them just being accountable for the hired contractor that did the damages, they basically, sent me on a wild goose chase and would not fix my home. Ultimately, it led to me then filing a lawsuit. And this was a situation that could have been fixed in less than 30 days. It has dragged out to almost 4 years. I'm still in litigation with them. There's probably additional legislation that I'll wish to push later on because the attorneys for the HOA has dragged this out longer than they should have. In the process of them not fixing my house, even after beating them in court in trial, it took them 7 months after the judge ordered them to fix my house. It took them 7 months to fix my house, and then they started harassing me. I then found out that they're charging Black residents late fees, that they're not charging white residents here, and they filed it in the circuit court here in Charlottesville, Virginia. There's been additional discrimination, hostile living environment that they've created for me and my children. They restricted my kids from utilizing the common areas, which is like the pool, the basketball court, the tennis court. They basically made my life a living hell for the last 4 years here. No one should have to go through this at all. No one. Not me, not you, not your children, not your children's children. No one. It's been ridiculous dealing with this. Again, it's been caught up in court. It's now sitting at the Court of Appeals in Virginia. It's a waste for me. To me, it's a breach of fiduciary duties and a waste of our money that we pay every month for our dues to handle the things that should be handled, but instead they choose to fight only me. And again, I want to be clear and state that they didn't just damage my home, they damaged every home that was in this cul-de-sac. However, I was the one that found the issues and I stood up for everyone in my community. I just want to ensure that this bill and these protections offer some type of remedy to someone that does experience this, that does live through this, because no one buys a house to have, when they walk outside, that they have to deal with everyone looking at them as a villain because they don't want their home damaged or they don't want to live with water coming in or rats running in and out of their house in the wintertime. So I would...
Thank you very much.
Couple of points about that testimony.
Yep.
Ms. Hudson won her case in circuit court, and the other side appealed it. But this case doesn't really affect her case. This legislation doesn't affect her case. It's much broader than that. She was just concerned about this sort of situation occurring in the future. And the second thing that's interesting about this is that Tanisha Hudson was a page in the House of Delegates and a page in the Senate in the 1990s.
Got it. So that's where she got some advocacy skills watching us in action.
She stands up for herself, and she learned that right here.
Gotcha. Well, I appreciate that. I guess my question, so this is broader than, because I didn't hear anything in that testimony that sounds like quid pro quo harassment to me. So I'm just curious as to what the nexus is.
I guess if she told more of her story,
I don't know if we need to.
She would probably tell you that there were things that were done because of things she had done, that there were steps taken. That she did not get the response that she would have hoped for, in part because of what she did, who she was, and because of the steps she had taken. And her concern, and she expressed this in part, is she feels that some things are done for racial minorities that aren't done for Caucasians.
Right. That's, again, That's fine. I think that's straight up racial discrimination.
It is.
And it's retaliatory action. Again, quid pro quo is usually typically has to do with sexual harassment and requests for sexual favors in exchange for something when we talk about quid pro quo versus you're being retaliated because of a specific allegation that you made. It may sound like quid pro quo, but it's straight up discrimination. I'm not sure. I don't mean any harm to your bill. I don't know that your bill substantively changes Virginia law a whole lot. I think we restate some federal law, maybe more explicit, and maybe give some folks some things to point to in Virginia code. I think the concern we heard from the AG's office is we don't want to, in an effort to be more explicit, leave anything out by accident. And so that's, I think, why the AG asked us to add a lot more words
I think you're right.
to the bill.
Yes, sir.
All right. Anybody else have any questions about this legislation? All right. So, is anybody from the AG's office here by any chance? All right. We can go ahead and move this forward. I will probably want to. I know I don't doubt that this is substitutes from the AG's office. I may between now and full committee ask them a little bit more, make sure that they're still comfortable with this.
Absolutely. A couple of folks from the office visited me. We talked about it right after it got through the Senate, and I asked them to make suggestions if they had any, and they did. That's where this came from.
Got it.
Report with substitute.
All right, it's been moved and seconded that we report with substitute. Clerk will open the roll. Oh, here. Oh, there we go. There you go. So as long as we had one red number on there.
Okay, thank you very
Wait,
much.
Delegate, I'm sorry, hold on. Clerk, I think you're in the wrong seat.
I'm sorry.
Well, how did Delegate Blox vote no on that?
I'm sorry. That's all right.
You're fine, Sarah Dees. We'll fix the.
I don't hold grudges.
Blame Blocks.
Zach got it right now? I believe 6-1.
Yep. All right, 6-1 with Delegate Austin voting no at his own terminal.
I did
All
that
right.
so we'd watch it, Marcus.
All right.
I need to know more about it.
Understood. Thank you. No, I appreciate you doing that.
Listen to your
Yep.
position.
All right. All right. Is there anybody else, or are we done? All right. There's been a motion to adjourn.
Yep.
Properly seconded. As many as favor of that motion, say aye. Aye. All right. We're adjourned.